may want to put in your document. Because if you're going to name someone to make a decision for you when you may not be able to about whether you have a certain type of surgery or not, if you don't have the capacity at that time to make a decision, well, hopefully you will have talked about that so they kind of know what your wishes are and they know how you feel about certain things. So in that healthcare document, one of the things that I also like to tell people that they should consider putting in their document is this is where I would also put, if you have any special instructions for the person that you want to carry out your decisions, that person is called the agent, okay, in these documents. So if you have something very special that you want your agent to do, for example, I want my agent, my husband, to make the decision about a healthcare if I can't, but I would like him to at least consult my parents in the event that it's not an emergency. So you can really be kind of creative and build in what it is that you're looking for in order to really reflect what you would really want to happen. The other thing that I often encourage people to do is if they have an idea about either cremation or a funeral or what they would want if they were to die, even though this is a living will and it's meant a living will and a healthcare surrogate designation and it's meant to be, while you're alive, oftentimes if you bury what it is that your wishes are, in a document somewhere else, it's not as likely to be found. So if at least it's a mention of it is made in this document, that chances are someone's going to see before you actually pass on. So it's always just a kind of like a good idea to just put it in there. And then, so those are the two, what I call kind of healthcare related documents. And I tend, my personal professional opinion, I like to put them together in a single document because that way it's one document that someone's keeping track of that you can give to your healthcare provider. So I often get asked, well, now that I have this document, what do I do with it? I always say definitely take it to your primary care doctor, and you want to make sure that you keep that on file there. And then every time if they give you a referral to another physician, you would want to bring it to that doctor's office. And of course, if you ever know that you're being admitted to a hospital or going in for some kind of surgery, you want to be able to provide that at that time. A lot of doctors' offices will, have a form that they want you to sign, and in terms of releasing information, a HIPAA release. The healthcare surrogate designation can cover that, and you can do separate HIPAA releases for additional people that you would want maybe to have access to the information, but not necessarily make a decision for you. So, and the other document that as a lawyer we don't do, but is a medical form that you might be asked to fill out is a DNR, which is the do not resuscitate. And so in that case, I call that's the PADLS document. And so for me, I would like to have a chance. So I, at my age, would like to be resuscitated. But I do, for example, have a living will that says in certain conditions, I do not want life-sustaining measures. So those are just differences between those that I like to clarify. So those are the healthcare documents. And then if you think about, well, what happens, again, we're talking about alive but incapacitated, what happens with our property and our finances? And that's when we really talk about a power of attorney. And these are really, really powerful documents. And powers of attorney are not all created equal. And so you could have a very narrow power of attorney, meaning it only gives someone a certain power for a short amount of time. The best example I can give is you could go to the DMV and you can give somebody the power of attorney to help transfer your car if you couldn't do it yourself. That is it's for a limited of time, it's for a very specific thing. But that's a power of attorney. You as the principal are giving somebody else as the agent the ability to stand in your shoes and do something for you with respect to your property. And so most of the time when people think about a power of attorney, they think about it in its use, in its context to pay bills for someone if something's happened to them. And so that is a very common reason to have a power of attorney, but a good power of attorney is much broader than that. The power of attorney that I would want, my grandmother to have if something happened to her is going to cover a lot of things. And when you cover a lot of things, there are a lot of caveats that the person signing it should absolutely know and understand. So, for example, there are what we call superpowers in Florida. And every time I say that, I want to put on a cape and I want to go like this. But in October of 2011, the law changed. And the law now says in Florida that if you want your agent to be able to do certain things, you need to specifically initial next to that superpower. So, what are some of those superpowers? Some of them are the ability for your agent to create a trust, okay? To be able to make a gift on your behalf, okay? To be able to create or change beneficiary designations. So they are above and beyond just being able to, for example, sign a check in your name and pay your bills that you're not able to, okay? It's beyond being able to deal with your real estate if you wanted to sell it. These are certain actions that really are very powerful. And even though an agent has a fiduciary duty to make sure that whatever they do is in your best interest, these specific superpowers are so big and they are so powerful that I want my clients to really know and understand why you would want to do them and why you may not want to do them. Or, for example, if I have a husband and wife that are naming each other as their first person, as their to be a power of attorney, and then maybe they're naming a friend or somebody else later, you may want to, for example, they may want to give their spouse much more power than they would their alternate. And so it's really thinking about what that looks like and specifically writing that into the document. Because one of the things, and the reason why it's so important, is because when you're on the other side of this, and let's just say, for example, I get a call and it's the power of attorney for a mother, and they said I should see an elder law attorney. I say, okay, so I look at this power of attorney and I'm checking to see which of these superpowers is initialed. Because if, for example, the mother is over income in the world of Medicaid, the only way to fix that is a very simple trust, but it's called a qualified income trust. The only way, if the mother is incapacitated, that I can have the daughter do it is if there's a specific initial next to that superpower to create that trust. So that's why I come out and do these things, because every time I have to say to someone, I'm sorry, I can't help you because of this situation, it breaks my heart. So I like to be able to tell people, okay, this is why it would be important. So when I'm meeting with a client, I'm having a discussion, because someone may say, well, I'm not going to ever need a trust. I don't really have a lot. Well, there are all kinds of trusts and there's all kinds of reasons. So it's my job to say, well, think about this long-term care situation. And then after they're educated, they say, okay, well, maybe I do want to check that superpower. So these are the conversations that need to be happening more often. And this is something that I'm trying to get the word out so that way people have a better understanding of what's going on in a document. Because I get all the time, well, can't I just pull the power of attorney off of the internet? You absolutely can. And you can absolutely, if you get it validly executed, it's not as though it's an improper it's not as though it's an improper power of attorney. But again, what I said before is they're not all created equal. So it may not do what you need it to do in a certain situation. And so I always say to people, like, if you have given your agent under your power of attorney a tool belt, like, how many tools do you want to give them to help you in a situation? And one of the big ones is also like being able to change your beneficiaries. That's a really powerful thing, and it may only be appropriate for a husband and wife to have it, and not other people to have it in that situation if you need to do it. So it's just one of those things where it's a powerful document, but you really have to know and understand some of the things so that you have one that is really good, that will get you through all the stages that you would want to get through. The other thing that's very important about a power of attorney is that when you execute it and deliver it, that's when it becomes effective. A lot of times people think that it just springs into action upon an incapacity. And that's not what the law says anymore. So when you do a power of attorney and you deliver it to the person, that means that they could take that power of attorney and they could register it at the bank where you have your account, and they could technically make transactions on your behalf. They could see what it is that you have. So it's really important to think about, okay, if I'm doing this document, am I delivering it now to the person that's going to be my agent, or am I just going to tell them this is where I have it and this is my safe place that I have it and here's how to get it if something happens to me? So those are 3 documents, and I mentioned 4, so I'm going to talk about the 4th one, which is the pre-need guardian designation. And so this document, it's a mouthful, and one of the things that people get kind of confused about is, well, I don't need a guardian, so why do I need a pre-need guardian designation? Well, here's why. We plan and we do these powers of attorney and healthcare documents so that way we don't have to have a guardianship, that court process that I told you about earlier. But sometimes it's inevitable. Examples of inevitable. Someone is still driving when they shouldn't be. They are a danger to themselves and to other people on the road. And even if they've done a power of attorney that gives their agent the ability to help stand in their shoes, if the agent takes the keys away and that person calls the police and says they're not giving me my property, my car, they've moved it, guess what? The police are going to come and say you need to return the car or it's a crime. And so the only way to deal with that situation, if it's that bad, is to take that person's right away. A power of attorney just gives the right to somebody else to stand in your shoes. It doesn't take your own right away, and that's what a guardianship does. So that would be maybe one reason that a guardianship would come into play. The other reason, I see is the instances of exploitation and scamming when it comes to finances. So the person is writing a check to Nigeria, or they've been exploited by someone. The only way sometimes to stop that, because the elderly person either believes in what is happening, okay, the only way to stop that check writing from, to get the institution to say, no, you can't have access to your account, is to declare that person incapacitated. And normally it requires then the appointment of a guardian so that those funds are then not held in the person's name anymore. They are held in the guardian's name, and that person cannot access them, so therefore they can't be exploited. So those are what I call the limited times that you get to a guardianship. And sometimes it is necessary, especially if people never do these documents to begin with. So then that opens up a whole host of other reasons why you might need a guardianship. So that pre-need guardian designation, though, it says now who you want to be your guardian if it ever comes a point where the court is requiring one for you. And so what typically happens is you name the same people in your power of attorney and your healthcare surrogate to be your guardian of your person or the guardian of your property in the event that that situation arises. The court will look at that pre-need guardian designation, and it's what we call in the law a rebuttable presumption. Meaning, if you have that document, the court must appoint who it is that you've said, unless they are unqualified. And so, for example, if the person that you named is going to be the guardian of your property, yet they've had a bankruptcy, then they might not be qualified to handle your finances, okay? Or if they're a felon, or if they're the ones that are allegedly exploiting you, okay, or that person, then they may not, then the court can say, well, no, I'm going to open it up and I don't have to go with who the person designated. But what it does do, and where I've seen it be helpful, is if there are, for example, a person that has multiple children, so siblings that don't necessarily agree on a course of action, and if a parent has designated which child is going to be the guardian in the event that this happens, then the court goes with that child as long as they're qualified. And it takes away the litigation around all that. And litigation is costly. So it's not always perfect, but it's at least one other way to potentially protect the person doing their documents, is to make sure that they have that pre-need guardian designation for themselves. Now, you can also do a pre-need guardian designation for a minor child. And so if I have, parents with minor children, they can also name who they would want to be the guardian of their children, their person and their property in the event that, both parents become incapacitated or upon their death. So those are the pre-planning advanced directives, okay? Do I want to ask for questions now on those, or do you want me to go to the estate planning first? If you have a burning question, I can. Sure. I'll repeat it. Okay. Okay. So I'm going to repeat the question so that we can hear it on here. Okay. So that's okay. Yeah. So she had a question about superpowers. When I was going over that there are superpowers in the state of Florida, and those are things that the principal can have the agent do for them. And one of them that I mentioned was, for example, changing a beneficiary designation. Okay. She asked whether or not those superpowers are optional, meaning does anyone have to initial a superpower? Yes, they are optional. So it's a yes or no. So you can say yes to some and no to others. But it's important that you go through each one and you can sort of modify them. So, for example, the example I gave of a husband and wife. So maybe you have a power of attorney and I've named my husband, but I've named my mother as a backup. Well, I may say in my superpowers that I want my husband to be able to change a beneficiary designation, but if my husband wasn't around and wasn't my agent, I didn't want my mom to make that change for me. And so it would be a yes or no. I could not have it in there at all. And then if you select no, okay, or just don't have it in there at all, it just means that it's absolutely, not going to be an option. So the problem that I see is that documents are silent on the whole issue. Whereas I am not sure whether the person who did the document knew that that was even an option out there to be able to give their agent, which they might have wanted to do. Mm-hmm. Okay. Yeah, no. And so to recap, the 4 advanced directives that are important in Florida are the living will, the healthcare surrogate designation, the durable power of attorney, and the pre-need guardian designation. Okay. All right. So let's kind of shift gears now that we've cared for ourselves in the event of our incapacity. And let's talk about, all right, we're dead. What are we going to do? What's going to happen to our stuff? And so there are a couple of things that I'd like people to kind of understand. So there is a process called probate. Okay. It's a court process, which if you have to use it, lawyers are paid. Okay. Every person who goes through probate, the personal representative or the executor of a will, the person that's in charge of making sure all those assets get to where they need to go, okay, when they go through that court process, there is a fee that they get paid and a fee that the lawyer gets paid. And so a lot of estate planning is trying to avoid probate, okay? And so there's a common misconception, which is that if I have a will, I avoid probate. And that is not true. And so one of the things that I like to really go over with people when I meet with them as potential clients is, okay, so I want you to understand that basic concept is that if I have a bank account in my own name and I die, the funds in that account, if I do not have a beneficiary named on that account, and let's say I have a will, it will go through probate. And some of those funds will be used to, if I have creditors, pay my creditors first, and then also pay the administration expenses. And then they will finally get to whoever I said in my will at the end of the day that I wanted it to go to. So if you start with that process, then we think about, well, how do we avoid probate? And the way that we avoid probate is by one, naming beneficiaries on accounts, which a beneficiary means if I die, is there someone named on file and in writing and a beneficiary designation that will get the money or the funds in that account upon my death? A death certificate will be issued, it will be given to the institution, and they will distribute the money to the person that you had named as your beneficiary. In that scenario, if you have $50,000 in a bank account and there is a payable on death beneficiary, that beneficiary will get it when you die. It doesn't matter what your will says. Okay? So that's one concept to keep in mind. So beneficiary designations can be a very useful tool to avoid probate. The other way to avoid probate is by using trusts. Okay? And so trusts, I like to tell people, are about control. And whether or not someone needs a trust is really unique to their specific circumstances and facts. But what I tell people is that most times you're thinking of a revocable living trust. It's something that you set up now while you're alive, that you are going to fund with your current assets that you have, or you're going to name the trust as a beneficiary. But that trust, okay, if you are alive while you establish it from the very first instance, then you're going to have control over anything in it. You're going to use it just like it's your own. But then once you're gone, you are probably going to have some rules for that trust, okay? And it's the rules for the trust after you die that are the important part about control. So, for example, a lot of times people will use a trust when they don't want the people that they want to receive the money, they don't want them to have that money right away. They're a minor child, they might be an adult child, but they're not very good with finances, or they may have an issue. Maybe maybe they have some substance abuse problems. Or, maybe they think that maybe they want to leave some funds to their grandchildren, but they want to make sure that it's used only for a specific purpose, like education. Maybe they want even their own children to have access to the trust, but only the income of the trust, and maybe not the principal right away until they're 40 or 50. It's these types of control things, that's really what a trust is all about. So it may make sense to have a trust depending on how much you have and what you want to do. And it may make sense not to have a trust and try to do what you need to do with beneficiary designations. But it really depends on the specific situation. The other type of issue where a trust is incredibly important is when you have a child or an adult with special needs. Because if they are receiving a public benefit like SSI or Medicaid, you do not want to inadvertently make them ineligible for that benefit by having them receive an inheritance. So if it was meant for you, you intended that to be for, a grandchild that has special needs that's on SSI, by giving that money outright, it could jeopardize their benefits. It would. It's not just could, it would, unless they did some other kind of planning. The planning you can do at the beginning when you're giving the money is so much better, okay? Because you're not having to necessarily, you can direct it more in terms of, if my granddaughter has special needs, I'm going to make sure that these funds are there for her. But if she passes away, then the rest of it can go, to my other grandchildren. You are controlling it more. So that's some of the ways that trusts work. And then if you have real property, then you're talking about deeds. Deeds are the way that real property is transferred. And so when you're thinking about, okay, well, what do I need to do? There are special types of deeds in Florida that help avoid probate, but there are pros and cons to using them. So one, for example, is called an enhanced life estate deed. Sometimes it's referred to as a ladybird deed. It can be a wonderful tool because what it allows someone to do is to transfer, to do a deed now that says, upon my death, this property is going to go, to my niece. But until that time, I still have the complete control whether to mortgage that property or sell it or do whatever I want with it. The problem is when you do one of these deeds is that if you later go to sell it, there have been issues that pop up with selling and title companies and wanting to make sure that those people sign off on those deeds. And if maybe your niece has predeceased you, then you're in a whole big mess. And so, in my professional opinion, what I typically do is say it's only done when we know that maybe death is a little bit more imminent and we're able to plan. But it is a way to help avoid that probate process from the outset and avoid probate. So deeds, trusts, wills, beneficiary designations. Those are the 4 things that are used typically to create an estate plan. But it's not always about the documents. You really have to be thinking about what the goals are that you're trying to accomplish and how that may work with one of these types of things and versus one of the others. So it's not always so black and white. Sometimes it is simple. The simplest case, if people come to me and they're like, okay, we have been married together for 40 years. We have adult children who are completely self-sufficient, and I'm okay with having everything outright. Okay, that's pretty easy. We're going to make sure that you have got your beneficiary designations correct. We're going to make sure you have your advance directives, and we're going to do a will as a just in case. Okay, but if someone's coming to me and they have, children from different marriages, or if you like your child but you don't like your child's spouse, that's another reason that sometimes trusts are set up. So it's not as easy as, it's not a one size fits all. You really have to think about what the interplay is between what you're trying to accomplish and how it all works together. Because one of the most common things that I've seen is I get this question always comes up is someone's moving here from another state. And I always say, okay, well, bring whatever you have in and we'll take a look at it. And a lot of times I will see a trust, and I will also have, with them, okay, well, what are your assets and how are they titled? And nothing that is an asset is titled in the trust. And I ask them like, okay, well, do you know if you ever put this in the trust or not? They're like, I'm not really sure. And I say, okay, well, so that doesn't, it might have been a perfectly good document, but if you never got anything into the trust, then it kind of defeats the purpose. That might go through probate and then to the trust, which you wouldn't want to have happen. So it's really about thinking about what it is that you're trying to accomplish and making sure that, if you're coming from another, state, and even if you're not, just making sure that you've really thought about and have a list of what everything is. What do you own? Because there are life insurance policies, there's timeshares that people don't think about. All those things are property. Burial plots that you may have, it's all property, and it needs to be considered as part of the plan so that we know exactly what it is, what's going to happen when you're gone. So I like when people walk out of the meeting with me, my goal for them is to know that if they did nothing that day, what would happen if they were incapacitated, and what would happen if they would die with all their stuff. Because I think it's from that point that then you can say, all right, well, I may not want that to happen, so how do we put something in place so we align it to their goals? So that's what I wanted to present today, and if you have questions, I'm happy to take them. Sure.
And this is about with respect to the trust.
Okay.
Where I've had clients who actually get married later in life.
Mm-hmm.
And what I was curious about, especially in the state of Florida, is I've heard 2 different things, that sometimes the trust doesn't matter, that if you put your assets in the trust and you get married and then it doesn't work out, there's still some entitlement to the spouse. I was just wondering what those contingencies might be.
Okay. So the question was, when there was a question about trust that she had heard in some places where it may or may not be certain in Florida, like even if you put something in trust, your spouse could still have access to it. Is kind of what was that the question? So let me give this little talk, and then you tell me if I answer your question. So in Florida, spouses have certain entitlements. Okay. A lot of them are centered around homestead, but they also are centered around something called an elective share. Okay. So let's start with homestead. So, according to the Florida Constitution, if you have a home and it's owned in your name, you cannot, if you're married or if you have a minor child, you can't, for example, devise your house in a will to somebody else. Okay? Your spouse and minor child, unless you've done a prenuptial agreement, okay, have a right that's given to them through the Florida Constitution that they can have a portion of that house. So you can't just disinherit them. So it's a restriction. Okay? So that would be one type of an entitlement a spouse would have. The other type is if what I call the elective share. So if you die and you, for example, even if you had, for example, you had $100,000 in trust, okay, and you left that trust. The trust says upon your death, it all goes to the son from my first marriage, okay, but person is married to second spouse, okay. If the $100,000 is the only thing that the individual died, that the husband owned when he died, then the wife would have an entitlement to some of that. Okay? And so I can't give you like it depends answer because it depends on the situation. But potentially, yes, even though the trust says it's all supposed to go to son in that case, yes, the spouse definitely has an entitlement to it under it's the statutory law of elective share, and they would get a percentage of it.
It is very close, and I'll tell you the situation because it'll be easier.
Okay.
But I had a friend who's very wealthy, and she was going to get married,
Mhm.
and she consulted her attorney, and her attorney told her even though her assets are in a trust, he would still be entitled to some of the assets. And
Mhm.
she decided not to marry,
Mhm.
and he doesn't have any people But that would be the case, and I'm curious about that because I don't know if she was really telling the truth or she was just trying to get out of the marriage. Like when she was talking to me about it, you know what I mean?
So the story that's been relayed, so we can have this on the audio, is that a woman was going to get married and she was very wealthy, but she went to see a lawyer and was told that the husband could have rights. The new husband could have rights, and she did not want to give up those rights to him. So ultimately, they broke up. Sad story. And they didn't get married. But if yes, that's true. If you don't do a prenup, you can waive anything by a prenuptial agreement. So if a husband, in that case, the potential husband, if they had both gone to see lawyers, he can waive that elective share. He can waive that homestead right. But there's obviously certain legal requirements that have to be met. But it could be the way to get around that is a prenuptial agreement.
And that's what I also heard is that if you have a prenuptial agreement, it doesn't necessarily mean that they can still fight back to it.
Anybody can sue anybody for anything, So yeah. Do you ladies have any questions? Otherwise, I will. Yes.
Question.
Okay.
It's a selfish one. I have an only child. Does that make my estate planning that much easier? Does it change anything?
So the question was if I have you are an o- you are only you have one
I
o-
have one
yeah.
child.
So I have
Husband and
okay. So husband and wife have one child. Does that make it any easier? Well, I think the questions are one, do you trust that child? Right? For the incapacity issues, are you going to have that one child make all those decisions? Can that child emotionally do that given the situation? And do you have any backups for that child if you do think yes, that child is a good person and they can handle it? Do you have any backups? And if not, then the question becomes, is there some way to build in a backup? And there might be other solutions. For example, you could have a professional. Yeah, you could have a professional that has to be worth the money that you could pay to help carry out those wishes. So there are individuals and companies that provide services. They are case and care managers. So for healthcare decisions, okay, they can do they can stand in your shoes and make a healthcare decision if you have like no family, or you just don't trust that your family is going to do what you want them to do. You could name a professional. You would meet with them ahead of time. You would talk with them about what their fee is, and you could name them, and they would meet with you, and they would go ahead and make those decisions for you if you couldn't. But more importantly, what I think is I think the takeaway would be, if you're going to name your daughter or somebody else, have you given them the tool or the knowledge to be able to carry out what your wishes are? So, for example, you could give them the name of a good case manager that you would say, you know what, if something happens to me, I know that I want you to make the decision, but I want you to hire this person to help feed you the information, because I know that you're going to be stressed out. I know that. And I don't want you to have to go it alone. So here's the name and number of somebody that can really help. They can, figure out which is a good placement if I'm, in the hospital and need to be placed somewhere. So in one sense, it makes it easy. But if you have an issue on alternates or how trustworthy that person is, then it just becomes a little bit more complicated. Yep. All right. Yeah.
Couple questions. Can a POA force a person to move to, for instance, an assisted living facility or a memory care if it's recommended by the physician, or is that only possible if that person is deemed incapacitated?
Right. So the question was, can somebody who is named as a power of attorney force the person into, like, out of maybe like a home and into an institutional living setting, like a memory care, or like a skilled level, or even assisted living? So, and that really depends on, yes, capacity. So, so if my power of attorney, my husband's my agent under my power of attorney, if I need help but I refuse, and I have capacity, he cannot just move me anywhere. It does not work like that. They can't say, nope, this is what's going to happen. And so there either needs to be that determination of incapacity, which a physician can say, okay, they're incapacitated, and it's really, you need to be a healthcare surrogate to actually be the one that makes that move for them. They're saying it's in your health best interest should be the document really that you're looking at. The power of attorney may pay for it, right? But it's the healthcare person. But again, if you have capacity, your healthcare surrogate can't just make a decision for you that you don't agree with unless you're incapacitated. But then the issue comes, because the next question is, well, what if they don't have capacity, and a physician has said that, but they won't move and it's not in their best interest? Then you're trying all these angles to get them to make the right decision, but if they can't, and it's truly going to harm them, they are going to neglect themselves, okay, and they're going to be a danger, that's when guardianship comes into play. Because you have to take away that person's right to determine their residence. Because that person no longer has enough insight and judgment to be able to, for example, care for themselves. So the way it usually plays out when I see it is, a person wants to stay at home as long as possible, and so they say, all right, well, you can stay at home as long as you have caregivers in place that come. But then they start refusing the caregivers because they think that they can manage on their own. And it turns out they can't. They're falling, they're going into the hospital, this is happening. The only way to resolve that issue is actually to declare them incapacitated legally, okay, and then have them moved. And usually that person is appointed they are appointed a guardian who can then has the legal authority to sign the papers to go ahead and move them. But that is the most difficult part of my job, and probably most care managers and everyone that's dealing with caregivers that are helping people, because you see that they need additional assistance, yet either they're refusing it and it's really harming them at the end. But you have to be very, very careful that their rights are not trampled on either, because really it has to be a situation where they do not have the capacity to understand, to make that decision before you go down the what I call the awful road of guardianship. Sometimes it's the last resort and it's needed. But that's, I mean, the long and short of it is, yeah, you it's the healthcare surrogate that would make the decision. And if a person has capacity, then they get to stay where they want to stay, unless there is, a court order that has a guardian that person's been declared incapacitated, and then that gives the authority to actually move the person.
So step one is declare them incapacitated.
Mhm. But you don't want to go around just declaring people incapacitated. I mean, that's the hard part, unless it really comes down to it. But yeah, that's how it is. And so typically, like, you try to do everything to avoid that actual guardianship. You try to just have, the physician there at the facility give the letter that says they're incapacitated. Try to take it to them and say, look, if you don't do this, I have no choice. And sometimes it does come down to the legal action.
I think you said this, but I just want to clarify.
Mm-hmm.
So then is there both a medical incapacitation and a legal incapacitation?
Mm-hmm. So to be declared legally, the question was, is there a difference between medical incapacity and legal incapacity? So a lot of times when physicians are saying someone's incapacitated, usually it's in the context of, can that person make their own medical decision to go home or not? Okay. Determining somebody legally incapacitated is much broader. And so when that happens, so when someone petitions the court to declare someone incapacitated, some things are going to happen. A doctor, nurse, and social worker, examining committee, are going to examine that person. And they're going to be doing an examination that's based on whether or not that person has the ability to function, to exercise certain rights. So the right to determine where they live, the right to make healthcare decisions, the right to manage their own property, the right to vote. Okay. Some things, I've had people where some people have capacity in some areas, like they can still make their own healthcare decisions, but they really cannot manage their own finances. Okay. And so you could have capacity in one area and not in the other. And so when a court, what happens is then that person also gets an attorney when they go to court, and ultimately the court will look at all of the evidence and then determine whether or not the person is incapacitated, whether it's a total incapacity in all areas or it's just some of those areas. So a legal incapacity is usually a lot broader than what a physician will sign. Now, we will also have physicians look at people and evaluate them for purposes of, if I know somebody maybe has been diagnosed with some, like, early stages of a dementia or has memory loss, I'm going to want them to go see a doctor too, to see if there are certain neuropsychologists that will evaluate for capacity to enter into their estate planning documents, because I would want to know from a medical perspective what they think about that. So that way, I mean, I have an ethical duty. I can only do documents for people on a day that I feel like they have legal capacity. So if there's something that's making me question it, I may say, I really need you to go see go get an evaluation for capacity from a physician and come back to me, and then we'll talk about it. So that way I have a solid understanding, because it's hard. I'm not living with this person. I'm not seeing them every day, and I'm just a lawyer and definitely not a physician. So, well, thank you all for coming and listening. Did you have another question? Oh, okay. Yeah.
Just another quick one. Why would I need a will if I have designated beneficiaries on all my accounts and like a POD document?
Yep. So it's the just in case. Okay. So what happens if, when you died, it was the result of a car accident. Okay. And it wasn't your fault, and your estate, okay, because when you die, somebody's got to be able to collect those funds if it wasn't your fault, right? Somebody's going to be sued, right? Money is going to come into your estate, okay? And we need to know where it needs to go. The will says where it goes, okay? So you also could have, maybe you forgot to title an account. So I've seen it lots of times where they thought they had beneficiaries on all these accounts. Oops, you missed one. Okay. Or, you see it where if, maybe your someone had died before you, maybe your mother had passed away, and you're set to receive that inheritance, but you die before you receive it. Your will say where it needs to go. So it's important to have one because in the event that you have something that if you were trying to have all beneficiary designations, it would at least tell you where to go. Yes, it would be subject to creditors and the estate administration, but you need to have that so that way it says it directs it where you'd want to go at the end of the day. If Yes. So if I have 5 accounts and I remembered to put beneficiary designations on 4 of them, that 5th account has to go through probate. And if you're going through probate, either the state's going to decide who it goes to, or your will, if it's something different than husband, spouse, kids, there's an order that's in the statute. If you want it to do something specific, your will would say where it goes. And who's the person in charge of making sure it gets to where it goes, your personal representative or executor. Mm-hmm. Yes, you always do a will because if in the instance that you forgot something, it's like that catch-all. We call it a pour-over will, and we're going to pour it into the trust. So even though, you have to go through probate for that piece of property, at least you're getting it funnels into that trust. Absolutely. So creditors can still come after the trust. So you still have to do a notice of trust when someone dies, and they do have to. Mm-hmm, yep. So you can't avoid the creditors by doing a trust. Okay. All right. Thank you so much for having me. This Financial Wellness Center is amazing. So thank you for having us and being able to educate.